code of judicial conduct is contradictory and presents empty promises. Arizona Code of Judicial Conduct is presented in the Rule 81 of Arizona Supreme Court, and it is a code of contradictions and empty promises. At first glance, the Arizona Code of Judicial Conduct reads like a declaration of noble duty. It announces that judges must uphold the law, avoid impropriety, preserve impartiality, and conduct themselves in a manner that promotes public confidence in justice. The canons are short and striking. The 4 canons declare that judge shall uphold and promote independence, integrity, and impartiality of the judiciary, and shall avoid impropriety and the appearance of impropriety. He or she shall perform the duties of judicial office impartially, competently, and diligently. Judge shall minimize the risk of conflict with the obligations of judicial office and shall not engage in political activity. On the surface, this is exactly what the public would expect: a strict code, a leash on power, an ethical compass to keep judges aligned with the law. The escape hatch, however, is in a preamble. Instead of reinforcing strict obligations, the preamble quietly expands judicial freedom. It tells us the judge is an arbiter of facts and law. This phrase sounds noble, but it carries a dangerous implication. The judge is not simply applying law to established facts, but actively defining what the facts are, what the law means, and how the two should interact. In other words, judges are licensed to reinterpret reality itself according to their own sense of right and wrong. The preamble also makes clear that the code is aspirational, not exhaustive. It is written as guidance, not as strict command. That flexibility is the true escape hatch. It means there are no strict obligations to do anything one way or another. Every rule can be softened, every principle can be reframed, and every safeguard can be bypassed under the broad umbrella of judicial discretion. The result is not a uniform standard of justice, but a patchwork of personal philosophies. One judge may enforce deadlines rigidly, another casually excuse them. One judge may see a disclosure violation as misconduct, another may dismiss it as harmless. Each can point back to the preamble as cover, the built-in license to interpret and reinterpret as they see fit. Rule 81 fills its ethics with the word flexibility. And what appears to be a rule is, in practice, nothing more than a suggestion. The canons sound mandatory, but the preamble makes them optional. The controversy. If judges are truly bound by law, then Rule 81 should be rigid, with bright lines that trigger consequences when crossed. But Rule 81 is written as aspiration, softened with commentary, loaded with disclaimers about judicial discretion. So which is it? A leash on judges or a shield for judges? The reality is that Rule 81 is more shield than leash. Judges can point to it to reassure the public. See, we are bound by ethics. But when challenged, they can just as easily point to its flexibility. See, this is within discretion. The code polices appearances, not conduct. The real question is, why do we need laws, rules, and guidance if most of the population cannot predict what the judge will decide and why? If everything is based on the judge's mood, views, and attitudes towards different segments of population. The judges in most cases favor lawyers against pro se litigants, even if lawyers committed multiple violations. There is no rule of law, but the rule of preferences of the judges. Enforcement in name only. The Arizona Commission on Judicial Conduct exists to enforce Rule 81. It can investigate, censure, suspend, or recommend removal. In theory, it is the guardian of the canons. In practice, the Commission dismisses the vast majority of complaints. According to an ABC 15 investigation, 97.2% of complaints filed with the Arizona Commission on Judicial Conduct between 2006 and 2020 were dismissed. National studies echo this pattern, with the National Center for State Courts reporting that most complaints filed with judicial conduct commissions, generally more than 90% each year, are dismissed. The Commission's own public decisions page makes the practice explicit. Complaints based on alleged legal errors are routinely dismissed. In other words, judicial misconduct is treated as existing only when an explicit ethical rule is violated. Everything else, misinterpretations of the law, disregard for procedure, or unequal treatment of litigants, is categorized as mere legal dispute, left entirely to discretion. This distinction creates abnormality. Clear violations of legal rules are brushed aside as non-ethical. In my own case, the judge excused a late answer to a plaintiff's complaint, even though Rule 6b(1)(b), named extending time, specifically requires a motion showing excusable neglect. When I raised the issue about this rule, the judge simply said that is not how we do things around here. What should have been a clear violation was reframed as a matter of local practice, beyond accountability. There are precedents showing that serious misconduct should carry consequences for judges. Yet in practice, the overwhelming number of dismissals shows that judges are rarely held to that standard. And so the pattern repeats. What looks mandatory is actually optional. What appears as a safeguard becomes a rubber stamp. Independence becomes immunity. Rule 37C1 and 2 and Rule 81, a shared pattern, Rule 37C1 of the Arizona Rules of Civil Procedure, is supposed to ensure fairness in the exchange of evidence. It says that if a party fails to disclose required information, such as documents, witnesses, or facts, that party is not allowed to use that undisclosed material later in the case, unless they can prove the failure was justified or harmless. In simple terms, it's meant to prevent trial by surprise. Rule 37C2 deals with failures to disclose or to correct inaccurate information. It authorizes the court to require the offending party to pay the other side's expenses on motion and if appropriate. Those two small phrases, on motion and if appropriate, quietly drain the rule of its strength. The first transfers enforcement away from the judge, making accountability dependent on whether a litigant dares to challenge the violation. The second gives the judge total discretion to decide whether any consequence will follow. Together, they transform a rule of obligation into a rule of convenience. The court is no longer required to uphold the integrity of disclosure. It may simply choose to do nothing. That short phrase changes everything. It turns a mandatory rule into a matter of choice. The promise of accountability becomes optional, depending on who is deciding. The sleeping watchdog of Rule 37C. Rule 37C(1) was written as a simple safeguard. If a party fails to disclose required information, they may not use that undisclosed evidence later, unless they can show the omission was justified or harmless. It is a rule meant to ensure fairness and prevent trial by ambush. Yet in practice, the rule lives and dies by a phrase that appears harmless but is fatal to accountability: on motion. This wording transfers responsibility from the court to the litigant. Instead of the judge actively enforcing disclosure fairness, the burden is dumped entirely on whichever side is brave enough to point out the violation. And if that side happens to be pro-per litigant, the punishment often follows immediately. A pro-per litigant who dares to invoke Rule 37C becomes a nuisance in the eyes of the system. Their motions are labeled premature, untimely, or unnecessary. The pro-per litigants are told the issue can be addressed later, which in judicial language usually means never. By the time later arrives, the damage is already done, the false evidence accepted, the record sealed, and the rule rendered moot. And so, the act of defending fairness becomes rebranded as vexatious. The litigant is accused of filing too much, of burdening the court, or, in the more creative rulings, of violating the judge's unspoken right to a convenient nap. The court's silence then becomes self-validating. If the judge never ruled on the issue, it must not have mattered. But this chapter is not about judicial comfort. It is about the duty to uphold integrity in every action of the court. Rule 37C is not a suggestion, it is a command of fairness. When judges treat it as optional, or worse, as an inconvenience, the rule ceases to function, and justice becomes dependent not on law, but on personality. In essence, Rule 37C exposes the quiet fracture in our system, a rule written to enforce fairness, but rewritten in practice as an option for convenience. The pattern does not end there. Rule 81, which governs judicial conduct and transparency, mirrors the same architecture. Both were designed as safeguards for integrity, yet both surrender that integrity through soft language, on motion, if appropriate, reasonable interpretation. These words sound procedural, even harmless, but they function as escape valves, allowing the court to appear bound by law while remaining free from its enforcement. Together, these rules illustrate a consistent theme across the judiciary. Accountability drafted into text, erased in application. What should be a duty becomes a courtesy. What should be enforcement becomes interpretation. Rule 37C and Rule 81 thus stand as twin examples of how justice can be declared mandatory while practiced as optional, not through defiance of law, but through its language. Rule 81 follows the same pattern. It calls for integrity and impartiality, but then softens those demands with language that leaves enforcement up to reasonable interpretation. It forbids misconduct, then explains that what counts as misconduct depends on context. The result is a recurring design, rules that look like commands but act like suggestions. They contain their own loopholes, written as discretion. Accountability appears in text but disappears in practice. Discretion disguised as justice. This is where the illusion of fairness takes hold. To the ordinary citizen reading the rulebook, everything appears strict and principled. Failure to disclose evidence will lead to exclusion, false denials will lead to sanctions, misconduct will lead to discipline. But in practice, the decisive words are always the same. The court may. That single phrase transforms justice into a matter of preference rather than principle. It gives those in authority the power to enforce or ignore the rule according to their own comfort, bias, or convenience. What should be an equal standard becomes a moving target. The ordinary litigant, especially one without counsel, learns that the law's promises are written in disappearing ink. Accountability is never truly denied. It is simply postponed, redirected, or excused under the banner of judicial discretion. Thus, discretion becomes not a tool for fairness, but a shield against responsibility. The pattern repeats across the system. Rules written as guarantees become instruments of uncertainty. Justice is spoken in the language of firmness, but practiced in the language of choice.